have now started speaking of data economy. It is not say currency-led economy or gold-led economy or reserves. Now data is the key. Data-related economy. The recent one of the persons, I forget his name, who had spoken in international conference, said data is the new petrol. The petroleum products are very costly, but now data is going to be more costly, and there is the era of data. And how do you protect this data? What kind of technology you are going to use to protect the data? AI is one of the things, artificial intelligence, which uses the data and can do anything. We can do anything because data is available. In such a time, what about a refugee? Who is a refugee? How do you define refugee? What are you going to do with these migrants who are called as refugees? The refugees are the people who are forced to flee their country for one or the other reason, and they try to find a safe haven in another country. They are unable to return back to their own country because of the fear of prosecution, fear of what the other people will do who are staying there, who made them go out of the country. Then violence with the army, armed forces, or maybe some public disorder which has made them flee the country. In such times, when refugees are there, they are asylum seekers. They go to some country which gives them asylum. They are intentionally displaced persons. So there is a responsibility on the other country to help them. So in such a situation, I think there are about 120 million people who are forcibly, say, migrated to other countries and are working there. They are worldwide. However, every migrant, maybe in the form of a refugee, carries his own story. He has something, some reason for which he has gone out of his country and is coming to a new country. He may contribute, he may bring bad memories from one country, but he may contribute to the new country which is developing, or he may become a nuisance also. We don't know, because it all depends on what kind of background he comes from when he is migrating from one place to other place. So in such a situation, giving them access to food, finding out their medical history, what is currently going on with them, what is their identity, which country they belong, etc. All the data is very important, and that data has to be kept. In such a case, having the data about refugees is very important, because through that we can have a kind of census in every country in which asylum they are seeking asylum. Now, what kind of technology are going to use? You already know technology has revolutionized the human space. There are very simple thing that we know is biometric, or say biometric attendance, that we all know. So biometrics, using iris, using scans, fingerprints, so many things. All of us are well accustomed to our Aadhaar card, and all of this we have come across. So we have to provide such type of, say, technology for all the refugees. They have to give their data, which is unhackable. Otherwise, people may steal that data, may try to, say, replicate the data in other forms. Not necessary that every fingerprint is space is free nowadays. It will be occupying some space, but that space also can be hacked in the cloud. So in such a situation, how do we go for data protection in this time? But at what cost are we doing all this? When we collect the biometric of a persecuted minority, we create a permanent record, and they vulnerably give that. They are vulnerable to the new country, the new laws, etc. They give all their data. Then, will the data be breached? Will it be hacked? If it is hacked, what will happen to it? Everything is very important. So, whether fleeing one country and going to other country is safe for their life is another question that we have to ask. So, in a rush to privatize or digitize the data, we should not, say, trade the privacy of another person. We should not go into that part. So what do we need to do? Legal people, legal scholars have to tell us how the gap can be bridged between technological capability and legal accountability. The relationship between this capability and the accountability is one of the most significant laws that has to come up in modern law. Say, as of 2026, we have something called as the pacing problem. Technological capabilities often evolve exponentially, while legal systems rooted in precedent and legislative consensus move linearly. So legal has its own way of moving forward, whereas the problems related are exponentially moving forward. So there is a gap there. How do we bridge that gap? The sovereignty gap is one of the things where most data protection laws, like the General Data Protection Regulation, GDPR, are designed for citizens with stable lives. Then how do we look at this law from the refugee point of view? Does it exist? Can we, who owns the data? Who is their host country? So many questions come there. So whether the refugee himself has to own the data, everything comes there. Another is informed consent. Can a mother fleeing a war zone give informed consent to have her iris scanned when her children's next meal is very important? Is there humanitarian context to this? The power imbalance, is it so great? So consent from the person, the refugee himself becomes an important thing. Then the another thing is the right to be forgotten. For a refugee seeking asylum or seeking a fresh start, the right to be forgotten is essential. Yet digital records are often permanent and they can be shared across any world, they can be hacked. So the right to be forgotten also has to be taken care of. In such a circumstances, where does higher education take us? What is the role of higher education? Why should the university host such a conference? Universities are hosting conference in which we are talking about technology, about artificial intelligence, use of artificial intelligence, the drawbacks of say giving the data like using chat GPT, etc. But nobody is talking about how secure the data can be, which is related to the very life of a particular person. And I think law schools should now think of interdisciplinary ethics, laws, produce some laws which are beyond these traditional laws, something like which is beyond cyber jurisprudence, and bring out a law for such kind of data, which is which can say go along with 1951 Refugee Convention law. Our role is to provide the intellectual rigor that is needed to draft policies that can protect the data subject as a human subject. So data has to be considered as human when we talk about data of refugees. So what is required nowadays, now in the present context, is we have to do some action. We have to make AI driven border management, ethics of surveillance, the future of international data governance. I urge all of you to keep one principle at the center. The principle is of do no harm. We should produce laws which will do no harm to anybody who is there. Let him be a refugee, let him be a stable citizen or whatever it is. Let everybody enjoy to live as a human in the world and make the society a more human society. I wish the conference all the success, and I wish may all the deliberations here lead to a more compassionate and more secure legal framework which will help everybody to have hope for a better future. I thank you for giving me this opportunity, and I wish the conference all the best. Thank you for a patient hearing. Thank you so much.
Thank you, sir. Thank you so much for insightful address, sharing on this data protection. Now, I am respectfully invite Ms. Ragini Tarakuru Zotshi, Associate Protection Officer, UNHCR New Delhi, to present a collaborative remarks on behalf of the UNHCR New Delhi. Ma'am, the floor is yours. Unmute. Ragini, ma'am? Yes. Yes. Good afternoon. Yeah. Mute and mute.
No, it is already unmuted, but we can't hear her.
No, we are not able to hear you, ma'am. You unmute.
No, it is already unmuted.
No, this is mute. Are you killing once again?
Okay, ask to unmute.
Yeah. Ma'am, you try now? We are not able to hear you. You try? Okay. Make it host. Make her host.
She's already hosted. Host.
So, she can share. We are not able to hear you, ma'am.
Ashmi, tell her to re-log in.
Can you leave and join back, ma'am?
Yes. That should be much better.
Yeah. Admit. And make rules.
Professor Benjamin,
Professor.
sir, Madam Yeli, I think she should also allow some speaker connections to the laptop. Let us give permission for it. Sometimes it does not.
Okay, ma'am.
Yeah. I think you should call over the phone and tell her to
Yes.
allow permissions for the speakers.
Still, we are not able to hear you, ma'am.
Is it better now?
Yeah, yes.
It's fine.
Okay. There was some permission issue, and sorry for these technical glitches. This is part of the probably may come up in the discussion in the next 2 days, since we're all talking about technology. Technology is making us connected here, but sometimes technology can also come up with issues, and I'm sure this is going to come up is somehow linked to the tone of the conference, but I will not make my interventions very technical. I want to keep it very short, but first of all, I want to congratulate all the organizers for planning this event, and most important to all of you, the participants, for showing an interest in the topic around refugees and more specifically around data protection, which my colleague Alexander will speak to in detail later, and we have a lot of speakers who are going to talk about it. But I represent UNHCR here, and more specifically, I'm working as a protection officer here in UNHCR India. For me, I want to reiterate that from a UNHCR perspective, it is very, very important the kind of topics we are talking about right now, and the interest being shown by so many participants. Is very relevant because when we are talking about refugees and we are talking about refugee protection, it is very relevant when we have more than about 117 million people forcibly displaced worldwide. In fact, when as UNHCR we were created post World War II, probably the world had thought that it's a temporary phase and we need a UN agency to work temporarily for 3 years to deal with the displacement in Europe caused by the World War II. But the reality is that world is not a better place. Displacement is not going to end, and we are at a very critical moment where there are a lot of discussions around the entire concept of asylum, the inclusion of asylum. A lot of things are happening, and I'm sure you're reading about it. But for us as UNHCR, we believe in the work that the world and the states collectively have entrusted us with, and the work is that we try to protect the rights of forcibly displaced people who have got displaced because they had to flee their homes, whether it is because of conflict, whether it is displacement, and we need international action to protect their rights. So, of course, the forcibly displaced community and also stateless people. And what we do is not alone, while it's the primary responsibility of the states to work on issues, but we, together with all the relevant stakeholders, what we try to do is deliver life-saving assistance and safeguard fundamental rights of people. And wherever possible, we also try to develop solutions for those people. And for the stateless people, we also work towards ensuring their country's nationality. Now, why I'm talking here is a little bit about what we do as UNHCR, also then to narrow down the topic today in the broader context of who refugees are and what protection may entail for them. And then within that protection framework, the conference comes back into a little bit more technical discussion about what protection in the context of the current world where there's so much about we're talking about digital inclusion, rights of privacy, these come up. But very important to set the tone because there's also a lot of confusion sometimes on who is a refugee, who's not a refugee, and often a genuine confusion, but sometimes also created deliberately. The mix up between who's a refugee, who's a migrant, who's a refugee, who's an illegal immigrant, possibly sometimes can be done deliberately to deny people the rights that the refugee protection may afford to some people and not necessary to others. But to make it very simple, refugees are people who have to flee from their country because are at risk of persecution, or they had to flee violence and conflict and had crossed international border. I think that's the most important distinction that all of us need to keep in mind. And that also adds to some provides protection to refugees under the international or domestic refugee protection regime, but also can create challenges because refugees are always foreigners in the country they have sought asylum, unlike people who may be internally displaced, who may have got displaced but continue to be within their country. As UNHCR, we also work with stateless people, and stateless persons are the ones who have no nationality. Basically, they are not recognized as citizens by any other country under the operation of the law. And stateless person may be displaced or may not be displaced. Again, in the context of the topic today, it's very relevant when we talk about the right to nationality or statelessness or risk to nationality, because it's often linked to documentation, which again is linked to the topic of when we're talking about digital inclusion, data protection, privacy. There's so much about inclusion and issues about documentation, which is a big challenge for people who are stateless because they're not considered citizens, and then they may not have that identity. And then what happens to the rights they have as a identity when there's no legal identity? All these issues may also come up in the delegation in the next 2 days in the conference. Again, a big reminder during the conference to all of us that it's actually the primary responsibility of the states to protect refugees. So whatever laws, policies ideally are being framed should be in line that these refugees are seen and counted as people. It is also in line with the SDGs that the world we have collectively believed in. This is the whole entire thing about leaving no one behind, including in the issues in the digital, when we're talking about the digital inclusion, about data, how do we ensure that refugees are included or the most vulnerable people are counted. And then we also adhere to the safeguards, their right to privacy. And I hope, because we have lots of senior academicians speaking here, and we have shown the conference has an overwhelming support from the participants who have signed up, and I'm sure there are many experts sitting as participants here, maybe experts in international law, maybe in data protection laws, maybe looking at privacy issues as academicians, as researchers, as students. And I would also urge that some of these issues that may come up in the conference, we may not have the answers right now, but as part of your academic portfolio, whether it's research, whether it's teaching, or whether it is supporting advocacy, these issues that will raise many legal and ethical challenges around would also be looked into and deliberated, not only in the conference but beyond, and become part of your work that you may envisage in the future. And I'm sure the conference will address a lot of questions, but will also provide a lot of openings, a lot of thought-provoking questions that the academicians who are sitting there, I can already see 300 participants, would take up. And from a UNHCR perspective, it is very encouraging for us. It is part of the way we operate and work with what we call the whole of society approach, is engagement with academia, and an extremely important academy, because academicians, we genuinely believe, are someone who can help in policy formulation, and as researchers, you all can contribute evidence for any policy or legal reforms, or how refugees are treated in their day-to-day life by the system, whether at an individual level or an institutional level. So with those few thoughts, I wish all of you all the best for the conference, and I'm sure there's a lot of learning from the conference from everybody, including the speakers and the participants, and the issues that are deliberated here will not only stay in the conference but would be taken up beyond this conference also. Thank you very much, and all the very best.
Thank you, ma'am. Thank you so much. Since you're coming from the practice background, there are some questions we received from the participants. You can question if you have any doubt with regard to ma'am's address. Is there any?
Yeah, I'm happy to address some questions, but if there are certain questions that may also be answered later because we have a detailed presentation by one of my colleagues from our bureau. Maybe some of those may get addressed later, but I'm happy to address questions right now also.
Right. So please raise your question. What is your question? Unmute.
Respected ma'am, myself Madhavindu Chakraborty from Assam University. I have one question. The question is that all the nations around the world are following the erga omnes obligations, but ma'am, the very essential thing is that we don't have any particular statute or a convention that particularly revolves around this issue. Like it is a very evident issue, and right to privacy is, ma'am, thing that is mentioned in the United Nations UDHR report also. So, ma'am, are there any present conventions, or is there anything that the United Nations is thinking about it, or is there any present convention or statute that is guiding this issue, or that is protecting refugee rights in this context of this conference?
I'm not sure if I am very clear about the question. Are you talking about the lack of law on gender refugee protection or data protection of refugees? Is it a broader question or a very specific to data protection?
Ma'am, it is both a narrow question and a broad question because, ma'am, as a legal researcher, ma'am, I was unable to find any present statute protecting data and refugee rights of the refugees seeking asylum in another country.
Okay, so if you're talking about refugee protection broadly, so in a broader sense, what governs the refugee protection at an international level is uh, what the basically what happens at a UN. What is UN? UN is basically a collective of it's an intergovernment agency where all the states of the world come together and they agree on certain things. So the states in 1950, under the auspices of the United Nations in the General Assembly, agreed that they will create UNHCR as an organization that works on refugee protection issues. And what they expected and want the UNHCR to do is part of the 1950 statute of UNHCR, which created UNHCR and which also articulates how and what kind of work UNHCR should do and what states wanted UNHCR to do and agreed that they will cooperate with UNHCR on. And then there's a 1951 Convention on the Status of Refugees, which is sort of then outlines the rights and responsibilities of the states and other things, which then narrows further down and adds to what is in the statute. This is a larger context. Now, if your question then comes down more specific to India on whether we have anything very broad to what is the law or what is the statute that covers refugee protection broadly in India. So broadly in India, you are partially correct by saying we don't have a specific law. So we don't have a in the context of India, we don't have a specific law which governs refugees. So we don't have one law. But there are different laws which create a framework. And the most important in that context, at an international level, bigger level, is the statute of UNHCR. Because as part, India as a country, as a nation, is also part of the UN system, also agreed when the statute was created, also agreed on what UNHCR should be doing and should not be doing. So that statute of UNHCR, which the world has agreed is one framework. Then coming back a little bit narrowing it down to India, we do have in Constitution of India, there are a lot of rights and protection in Constitution which are available to any person in India, including certain fundamental rights. Those fundamental rights govern everybody, including refugees in India. So that is again another framework. Then within the refugees, also not a homogeneous category. You have men, you have women, you have elderly, you have persons with disabilities. And as an advocate or a researcher working for refugee protection, we also have to look at what are these rights, what are these laws, are these laws applicable to any person in India? So, for example, just to give an example, the JJ Act, the Juvenile Justice Act applies to every child in India, which would also mean refugee children in India. So all these things create a framework, a broader thing. Then we also look at the judicial precedents. What could be possibly are there Supreme Court judgments, are there High Court judgments which confer refugee protection? For example, on the issue of education, there is a Right to Education Act which applies for any child of a particular age in India, which covers every single child. So these are different things. Then you look at international law. We look at what is customary international law, like the principle of non-refoulement, which means that you cannot send a person back to a country if there's an issue, which we may say we don't have a law, but it's a customary international law which is binding on everybody, including states who may not have signed the 51 Convention. So we don't look only at the specific law, but when we talk about framework, we look at everything. A policy framework, state practice, international law, customary international law, constitution, ancillary laws, and that's what we use. So as a researcher, if you're interested, I would also encourage you to look at all these aspects. Not only look for one specific law because we don't have it, but look at what else is there. I hope I answered your question.
Thank you so much, ma'am.
So Syed, I'm here. So should we start or Ragini ji, good afternoon.
Good afternoon, sir.
You finished or you are going to start?
No,
Acha,
I finished. I finished. We swapped places waiting for you.
okay. So
Okay, right. Thank you, ma'am, for answering those questions. May I now invite our chief guest, Honorable Vice Chancellor of Dharmashastra National Law University, Jabalpur, Professor Manoj Kumar Sinha, to address the gathering as a chief guest, and it shall be the inaugural address of this today's program. Sir, the floor is yours. Before we proceed with you, we would like to introduce you to our audience.
I
may
think
call- Yeah,
again
because
the it's a data protection. No, introduction is better, like hidden is much better than the disclosing.
we try to reduce it very narrowly. I
You
may
have
call
assigned someone
for
else
Ms.
for
Sarah
the
Benjamin
introduction.
to briefly introduce her. Yes.
Say if you have assigned someone else for the introduction, then I'll say yes. Otherwise, if you are going to introduce, you stop here.
I have someone else assigned.
Okay.
Yes. Yeah, please.
It is my proud privilege to introduce our chief guest for the inaugural session, Professor Dr. Manoj Kumar Sinha, the Honorable Vice Chancellor of Dharmashastra National Law University, Jabalpur. Professor Sinha is an eminent scholar and academic leader of national and international repute. He is currently serving as the Vice Chancellor of Dharmashastra National Law University, Jabalpur, and has previously held the prestigious position of Director of the Indian Law Institute, New Delhi. His academic journey reflects exceptional scholarship, having earned his doctorate in international law from Jawaharlal Nehru University, an LLM from the University of Nottingham, and his LLB from the University of Delhi. His areas of specialization span human rights, constitutional law, international humanitarian and refugee law, international criminal law, and international institutions, fields that lie at the very heart of the theme of this international conference. Beyond research and teaching, Professor Sinha has delivered lectures at numerous institutions in India and abroad, including leading law schools, the UGC academic staff colleges, the International Committee of the Red Cross, and ministries such as the Ministry of External Affairs and the Ministry of Environment and Forests. He has also served on the editorial boards of several prestigious national and international journals and has been a member of various statutory bodies, including executive councils, academic councils, and boards of studies of universities. His academic excellence and leadership have been widely recognized. He was awarded a scholarship by the International Development Research Centre, Canada, for his contributions as a young scholar. He has also been honored with the Great Indian Teachers Award and recognized as one of the nation's notable bar leaders by the Bar Association of India. Professor Sinha is also a prolific author and editor of several authoritative books on constitutional law, human rights, international criminal law, and governance, which continues to guide scholars, practitioners, and policymakers alike. We are indeed honored to have Professor Dr. Manoj Kumar Sinha as the chief guest of today's inaugural session, and we look forward to his invaluable insights as he delivers this inaugural address for this international conference. With great respect, I invite Professor Dr. Manoj Kumar Sinha, Honorable Vice Chancellor, Dharmashastra National Law University, Jabalpur, to kindly address the gathering. Thank you.
Thank you very much, Sarah, for nice introduction, nice and detailed introduction. Uh, I take this opportunity to profusely thank Professor Benjamin for thinking about us, requesting us also to collaborate for this wonderful exercise or in a wonderful international conference we planned for 2 days. I feel a little bit restricted in a sense because Ragini spoke about before me. So she might have touched upon many aspects related with the refugees. But let's start with the questions which were asked by some of the scholars to Dr. Ragini. And she also answered in a very effectively. The first, I think, refugee, whenever, so it's a kind of merging of international refugee law and domestic law. Refugee crosses who are refugees, then we seek help from the international instrument, as might have been told by the 1951. When it comes to the determining who are the refugees, then we have to look into the global definition existing under the 1951 Convention. Once we say he's refugees, then we look into the other condition, whether it's a. So ultimately, the determination of refugee status, either done by the UNHCR in the respective country, like for example, in India, we have Syed here. So we have asked UNHCR to determine the status of refugees coming from Afghanistan, refugee coming from the Myanmar also, refugee coming from Sudan and others. So some limited exercise we have given to the UNHCR office in India to determine. So while determining, they look into the international instrument, particularly 1951 Convention, whether the person who is seeking refugee status in state A or state B or state C, whether he satisfies the condition which has been laid down under the Article 1A of the 1951 Convention. Once the status has been determined, then he becomes part of the local populations. Though, of course, as a refugees, he integrate in the society. He can become the permanent citizen of that particular country as a part of the durable solution. He can opt for that. A refugee, because a refugee has a liberty to decide, once his status is confirmed, he has a liberty to decide whether he wants to go back to his mother country or he wants to stay in the host country. And that is very important, because the decision to go, and what situation I'm saying, suppose, for example, if a person who left his country at a time of great crisis or conflict or distance or whatever, and after 5 years, he finds that situation has improved back in the country. So he has an option to go back to his country, or he has an option to stay the new country where he has been granted the refugee status. The receiving state or host state technically he ceases to be refugees. Once, like, there is a cessation clause under the Article 1C of the 1951 when you cease to refugees. But the decision to go back, repatriation, rests on the refugees. And many of you are aware that Article 33, which talks about the principles of non-refoulement, and that is there. Coming back to the point which was raised by one of the young colleagues, that what are the protection? So he has all the protection of the domestic law. Once his status is granted refugee, it's not two separate law. Of course, like, employment and other aspects may be different kind of thing, but rest of the, he has a protection of the constitutional law, he has a protection of the other laws, because refugees gradually in the adopted country start integrating, start giving vocational training to the refugees, whether it's in Sweden, Switzerland. They don't want refugee to become a burden. So refugee can also become integral part of the local state, and that is the reason they are given language training, their skill and everything is there. So laws which are applicable in the domestic level is applicable. Now, like, as correctly pointed out by the Ragini ma'am, that Article 21 comes to the protection. Justice Puttaswamy judgment effectively applies to the refugee also, like a right to privacy. So after just 2017 judgment, landmark judgment of the 9 judges bench will be applicable to the refugee also. The 2024 Personal Data Protection Act, that will also available to the refugees till they are here. So all protections largely, I will not say free, but largely protections which are available to the citizens will also be in some extent and available to the refugees in any country, including in India. And that is the important part is there. So they have a data protection, whether they are in the Europe, whether they are in the India, whether they are in the any other country, that is particularly available to the refugees, and their identity is there. But you have to imagine why we are fighting about the data protection. And why? Because like situation, people are desperate to seek protection from persecution. So they search, they leave their home, they leave their documents, houses are burned, they are persecuted by the authorities of their own country. The state, which has an obligation to protect, promote, and fulfill the rights, start persecuting a person on the grounds of race, religion, nationality, political opinion, and membership of social group. So first, like, his identity, like, you are targeted because of your identity. You are targeted because of your religion. You are targeted because of your political opinion. So whole world comes to know who are being targeted. So we know that Myanmar, who are being targeted. Individual identity is difficult. That comes later. But collective identity we know. We know that Rohingyas, Muslim populations of the Rohingyas are being persecuted in a state of one particular state. And then we know that because of the religion. So collective identity is disclosed. Collective identity, then we like start knowing each individual. But when it comes to the whole world there, in case we know that the Christian population and Muslim population, there is a conflict and there is a persecution is there. In case of Ethiopia, in case of Nigeria, like President Trump has said, a particular group, the Christians are being persecuted, Christians are being targeted. So we know the entire identity of refugees who are being targeted. We know that neighboring countries who are being persecuted, who have a fear of persecution. So your identity is always disclosed to the whole world. It's not hidden. Your individual identity in the collective group is need to be protected. And that is very important. I will tell you an example. And it's Ragini will support in that. In India, when people enter, from the any part of the world, so first they will cross the border. And a journalist in a couple of years back, I'm missing the name of the case, but I will share with sir also. They crossed the India border, in Myanmar border, they entered in India. But from man, so who will determine their status of refugees? So as I said, that status will be determined by the UNHCR office in India. But these individuals have to travel from Myanmar to the Delhi. And in between, police may detain them. So this become a big issue. A group of journalists, a family of journalists, they enter in the Myanmar. They satisfy all the conditions. But they had a fear. If they take a flight from Myanmar to reach Delhi, put their claim before the UNHCR, there is a possibility they may be detained by enforcement authorities, either in train or in the plane. To have a safe passage, the family approached the Manipur High Court, and Nandita Haskar, she represented that case with along the. So court has granted, court has not determined the status of refugee, but court has granted safe passage to these person to go to the Delhi and put their claim that they are asylum seekers, they fulfill all the conditions to give the refugee status in that particular in that particular situation. So we see there is a lot of complications. So you know the identity of person, you know that particular person who is coming. So and refugee is particularly in desperate need of protection in the host state. The question doesn't arise too much on when a refugee, if you ask what they are looking for, they are looking for the granting of the refugee status. They are looking for the protection from the authorities from their own state. They are looking for other protection, economic, social rights are there. So these are the concern of the refugees where they go or where they stay in the any country. Today, it's also important to bring to your notice. We have a large number of populations not consisting of refugees, but it's a large number of internally displaced persons. So you can imagine internally displaced persons, populations have grown like significantly. When we come into the international level, we see that because of the lot of factors, the populations of the internally displaced persons have been grown significantly. When it comes to the refugees, people are not able to cross international border. Borders are being protected so tightly. The approach Vasudhaiv Kutumbakam or whatever you say, the states used to share, state used to take care of the refugees, state used to welcome the refugees in 1950s, 60s, 70s, 80s. But today we are in a 2025, whether it's Europe, whether it's other Asian countries or African countries, they are a rigid border. Strict border regulations are there. So movement of refugees, those who want to cross to save their life are unable to do so. The number of internally displaced persons increased. It doesn't mean they don't need protection. They desperately need protection. But unfortunately, guarding of border, strict guarding of border creates, so they remain in their own country. They can't cross international borders. So the major hurdle what we are witnessing in today. So sometimes we say internally displaced persons are increasing. Internally displaced persons are increasing. We never make an attempt to understand why this population is given a chance. Half of the internally displaced person will migrate to the third countries and seek protection from that particular country. So this is the major. So today, getting moving from one part to the another part is a huge challenge. You forget about the Europe. Europe is tightening. If we go back to the development or the global framework for the protection of refugees, I'm sure Professor Ragini might have told you that two important instruments are there: United Nations Convention on the Status of Refugees and 1967 Protocol. These are the two main instruments which governs the global refugee protection. Of course, we have in Africa, in 1967 OAE Convention is there. We have also in the Latin American countries, and we have very strong regimes in the directives in the European Union. So we have regional instruments for the protection of refugees, and we have global instrument in the protection of the refugees. In case of conflict between the global instrument and the regional instrument, technically global instruments should prevail over the regional instrument. But when we go back to the Europe, the continent which played an immense role in development of international refugee law framework, today is no longer interested to respect the 1951 Convention and 1967 Protocol. They say that refugee will be governed by their own European Union laws, their European Union directives of 2004, their other border control regimes. So what we see, the states which were instrumental in developing of the international instruments, today creating hindrance in implementation of the 1951 Convention and 1967 Protocol. Why? So this is like, I will take 2-3 minutes also in the 1951 Convention and 1967 Protocol, because and try to understand why person remains internally displaced persons, and how a people become refugees. Just for the sake of clear understanding of all of you, even if it has been said by the Ragini, I would like to repeat again by saying the main instrument is 1951 Convention. And according to Article 1A of the 1951 Convention, which says a person who has well-founded fear of being persecuted, it starts with a person who has well-founded fear of being persecuted on the grounds of race, religion, nationality, political opinion, or membership of a social group, and crossed international border. So crossing international border is equally important to seek asylum, to seek refugee status in the host country. There is a possibility you have a fear of being persecuted on the ground of race, your ground of religion, political opinion, membership of social group, but you fail to cross international border. As I expressed difficulties in today's context, you fail to cross international border. You have a fear of persecution, but you fail to cross international border. So what happened? Your status has changed. You are denied the benefits and privileges of refugees because you could not cross international border. You remain in the same country which is persecuting you, which is targeting you. So you have failed to cross international border. So you are seeking the protection from the state which is being persecuted. So that is the bad situation when it deals with the internally displaced person. Definition, when you I hope that some of the speakers will today and tomorrow also will speak. They will focus on the little bit on the definition under the African Union, OAU Convention on the Refugees, which has wider definition, which gives human rights violation, which talks about the armed conflict also reason for the refugees in the 1967 convention in when it comes to the refugees there. The second point which 1951 convention is, when this convention was adopted, those who were engaged in the drafting of the constitution, they never ever thought a refugee will become a perpetual problem. Refugee will remain an issue in days to come or years to come. They had an impression that refugee is a temporary phenomenon and it's confined to the Europe. It emerged because of the European context. It's a European context because of the two World War, First World War and Second World War. They thought about that. And that is why 1951 convention, when it was adopted in 1951, entered into force into 1954, but it has two limitations. One temporal limitation and other geographical limitation. So when you, without 1967 protocol, you read the 1951 convention, what you come to know that 1951 convention, it talks about the refugees prior to the 1st January 1951. So they thought, okay, after this, no refugees will be there. And it applies to European countries, other can also join. But subsequently, refugees started appearing in the other parts of the world, not in the Europe, other places as well. And that required, that demanded, the refugee convention needs to be revised, needs to be amended, needs to be enlarged. And that has compelled the UNHCR to think about it. And finally, in 1967, a protocol has been added. So what 1967 protocol has done? 1967 protocol has not done great or something. It has simply removed two limitations: temporal limitations and geographical limitations. After 1967 onwards, the 1951 convention opened to the entire world, and it is also both temporal limitation and geographical limitations have been removed by the 1967 protocol, and thus it's become applicable to the all the entire world. So this is the framework of the refugees there. When we look into our own country, we have a very not consistent policy. Sometimes we see that, if I have to say, sometimes we have very progressive decisions by the High Courts and the Supreme Court of India. Sometimes we have little bit different approach there. And recent time we have seen where court has looked into in a different way refugees. But time has come when we are living in a world which is moving closer day by day. We have a rights, we have a duties, not merely because we are citizen of a country A, citizen of the country B. We have a rights, we have a duties as a citizens of the world. What Immanuel Kant had said, we have a rights, we have a duty. So each rights has to be protected. I'll also say one thing for the Immanuel Kant has written a book in 1795, and what it says, Towards a Perpetual Peace. There he propounded that human being has a right to move around the world. They are the guest. So in 1795, Immanuel Kant says, every state has a duty to admit. We are as a whole, host state has a responsibility to welcome the people. Of course, he also added the people should not stay forever. So the host state reserves the right to ask them to go back. So some way, global framework, it supports the protection of the refugees in whether it's a theoretically or whether it's a conventional base, or even the domestic law is concerned when we talk about the protection of refugees. The other point, because a lot of questions are coming, I will go back to the question part. I'm saying that when we have a great law, we have Constitution Article 21, the Supreme Court of India has granted protected refugees. We have a very important case, which National Human Rights Commission versus the State of Arunachal Pradesh, where the two institution of the state, National Human Rights Commission, has filed a case against the state of Arunachal Pradesh because they were targeting the Chakmas. Chakmas were the third generation populations. In many cases, it's not the identity. Even in the cases of lack of enforcement, even the persons who were entitled to become Indian citizen merely by birth, by natural citizenship, that was also denied. So hiding your identity, the refugees are always exposed to the disclosure of their identity. You can't get any paper if you keep on hiding or protect. Of course, the state has an obligation, but the paper runs through various ministry. You are exposed to the government has a responsibility to see. So when you put your application for the refugee, puts an application for the citizenship of India, district collector will process that application according to the Citizenship Act of the 1955. Then it goes to the Ministry of Home Affairs. Then police verification, number of processes are there. So in the entire process, the information is shared by the authorities. And here the role of the authorities, not to target the individual who has applied, not to share the information to the other groups who targeting their prayer. So the protection, identity protection of the individuals, protection of the identity of refugee becomes very crucial when it comes to the sharing of the information. Refugee, like an exposed refugee, needs to disclose his identity, and he discloses his identity. He gives us the grounds everywhere, whether the UNHCR has a detailed information. So UNHCR has more responsibility to see that the data should not being leaked. Data should not be. Again, if the data is leaked, there is a possibility of people coming from the other country, the uh, country of origin, and there may be refugee can be targeted. So there are like an identity of refugees becomes very important when it comes to in age of technology. We are living in a technological era where sharing of information can put a refugee, his life, his protection is in danger by the local population as well as then from the outside. Refugees are not being welcomed anywhere. Today it's become extra burden. Refugees not being welcomed, and that is the reason IDPs are increasing day by day. Even the states which were very liberal in admitting refugees, including European states, now they have a very different. They want professional people are there. So some way the first half the 21st century is we have completing one decade of the 1/4 of the 21st century. We see that new issues are emerging every day, and their protection of refugee becomes there. If you disclose the identity, if you where they are not only identity, even the place where refugees are there is a possibility of conflict between the local populations and refugees. So there are a lot of issues where it's become essential, it's become necessary for the state authorities to ensure, UNHCR to ensure the identity of the refugees are protected in basis. the role of the judiciary becomes immensely important in such a situation. Any deviation, any failure, the court has to play an important role. Court has to treat refugees and citizens equally when it comes to the right to privacy. Puttaswamy judgment did not discuss about the, so we are enlarging the scope. We are enlarging the scope of the Puttaswamy judgment and saying that that will be available to there. We are not quite sure how court reacts when a real case comes before the court in the right to privacy or right to protecting the data of the refugee. We are not quite sure. Court may follow the same principles which evolved in the Puttaswamy judgment. Our court may say that there is a distinction between the judgment applicable to the citizens and non-citizens. So we are very uncertain, but we have a ground to believe that Indian judiciary is very positive when it comes to dealing with the rights of the individual, whether citizens and non-citizens. Their response, the response of the court, whether it's a High Court or Supreme Court of India, always very encouraging, supporting, and setting a path for the other jurisdiction to follow. That is the somewhere we can say with the utmost seriousness and conviction that Indian judiciary is very positive. Even the institutions which are working in the UNHCR and other institutions play very important role. It is important also to note, and I'm sure all of you are aware, that India is not party of the 1951 Convention, neither 1951 Convention nor 1967 Protocol. But we did not hesitate UNHCR to function in India. UNHCR functions, we have given a limited mandate to the UNHCR also to determine the status of refugees. In one hand, and on the other, when it comes to the court takes a very positive attitude in protecting the rights. I'm sure there are a lot of issues are there, but I leave it here by saying that refugees' identity is very important. You know the collective identity of refugees. When it's you say people, when you say a person or individual, you want to protect. So collective identity is known. I know that who are coming from Myanmar. I know who are coming from Afghanistan. I know who are coming from Bangladesh. I know who are going to come from Pakistan. So there is no problem. But I don't know who has come individually one by one. And those names are very important. Those identities are very important, which needs to be protected by the applicable law of the land. Applicable law of the land of any country, whether it's a Europe, India, or any country, if law which protects their citizen, law should not discriminate. Law should not discriminate when it comes to the individual with a dignity, right to protect their identity, right to privacy. It must apply uniformly to citizens and non-citizens. I'm quite sure the discussion which Professor Benjamin and Syed has planned will throw much light on it with this important topic, and some concrete ideas will come. To end by saying that constitutional guarantees, Data Protection Act, and all relevant acts are available to the refugees. But it's an interpretation, it's construction. Interpretation and construction depends upon the court. How court construct in the future, how court interprets in the existing lecture, that is we have to wait and watch and see the response of Indian judiciary. So thank you very much, Professor Benjamin, Professor Syed, and Ragini ji, and all of you for giving me a wonderful opportunity to inaugurate this conference and share some of idea with all of you. It was amazing. It was very enjoying moment for me personally. Thank you very much. Over to you.
Thank you, sir, for your comprehensive address and offering intellectual foundation to this conference. Now, it is my privilege to invite Mr. Alessandro Hilo, Senior DIMA Coordinator, UNHCR Regional Bureau for Asia and Pacific, Bangkok. to kindly deliver the keynote address. Before, sir, we proceed with you, we would like to brief about you to our audience, then we proceed further. I may call upon Ms. Sarah Benjamin.
It is my privilege to introduce a distinguished international expert in humanitarian protection and governance, Mr. Alexandro Tello, Senior Data, Identity Management and Analysis Coordinator with the United Nations High Commissioner for Refugees, Regional Bureau for Asia and the Pacific, based in Bangkok. Mr. Tello brings with him nearly 2 decades of international experience, having worked across diverse regions including Africa, the Middle East, Europe, America, and the Asia. He holds a bachelor's degree in international relations and a master's degree in human rights and conflict management, which strongly inform his rights-based and protection-centered approach to humanitarian work. Throughout his career with UNHCR, Mr. Thallo has served in both field and headquarter roles, developing deep expertise in data and identity management systems, including registration, biometric documentation, and population data analysis. These systems are essential for ensuring protection, access to services, accountability, and durable solutions for forcibly displaced and stateless populations. In his current role, he leads regional initiatives on ethical data use, data protection, and evidence based decision making, strengthening humanitarian responses across Asia Pacific region. We are honored to have Mr. Alexandro Tello with us today and look forward to his insights on how data, identity, and institutional capacity can enhance protection and resilience in fragile contexts. Please join me in extending a warm welcome to Mr. Alexandro Tello. Thank you.
Good afternoon, everybody. I hope you can hear me properly.
Yes.
Thank you for the invitation, and it's a pleasure to be with you today. I'm joining from Bangkok, regional UNHCR Regional Bureau for Asia and Pacific. And today I will discuss how UNHCR approach the protection of refugee data in this increasingly digital world where we are living, all of us in, focusing mostly on the legal and policy framework that guide us. For people forced to flee, refugees, data is not abstract. How we collect, store, share their information, their identity, as Mr. Manoj mentioned just in his initial speech, is important for us to increase the protection and find solutions for refugees, but it can at the same time also create serious risks. So I was thinking today to structure my keynote speech and presentation around three main questions. First, what do we mean by personal data and data protection for refugees? So we set a clear basis. Second, how does UNHCR General Data Protection and Privacy Policy operationalize this principle? And third, what does it look like in practice in the age of technology and digital transformation? So the key issue that remains throughout, I think, our 2 days together, and we'll focus my session is that we need to know. I mean, we need personal data and technology to protect and assist the refugees. But we must do so without creating new risk or misuse this information that could eventually exclude and create more risk for the refugees. Sorry, just 1 second. I cannot move my slide ahead. Let me try. Yeah. So, why UNHCR introduced in 2022 the general policy on personal data protection and privacy? As mentioned, UNHCR works in this is increasingly shaped by digital identity system, online registration, AI-driven analysis, remote service delivery. Every single registration, and Mr. Manoj mentioned it, we need to know who these people are. We need their name, their biodata, their data. This is registration, is the first entry point how an asylum seeker can submit their claim. We need this basic information. Every registration, every case management file, any cash distribution produces data that can protect, or if misused, can expose people, refugees, at serious risk. And for people who are fleeing persecution or conflict, the stakes are extremely high. Data about identity, the location where they are, their political affiliation, even their religion can put this individual and their family at risk if this information are disclosed with actors, with wrong actors. And UNHCR use data and technology to enhance refugee protection and solution while preventing these risks. This is why UNHCR has adopted a general policy on personal data and protection. And before turning to the policy, we call it GDPP itself, I would like to clarify three main concepts. The first one is about three core concepts that we use. One is personal data. The second one is processing of data, and the third one is data protection. So, what is personal data? Personal data is any information relating to an identified or identifiable individual. In our context, includes refugees, asylum seeker, internally displaced person, IDPs, stateless person, but also this policy covers UNHCR staff and UNHCR partners. These personal data can range from a name. It could be a phone number, a unique identifier. It can be case note, can be GPS coordinates where the person is, a specific needs, and a vulnerability of a person. It can also be biometrics, iris, facial recognition, or fingerprints. The second concept is processing of personal data, and UNHCR define it very broadly. Is any operation performed on personal data, from collection, storage, analysis, transfer, disclosure, sharing, and also deletion. So that means that the data protection obligation apply throughout the entire data life cycle. It's not just the moment when I collect the information related to an asylum seeker or a refugee, but the entire cycle, from the start up to the end, deletion. Third concept we mentioned is data protection. So data protection is the systematic application of principle that to protect the privacy and the rights of the data subject. In this case, the asylum seeker, refugees, IDPs, and stateless persons. The objective here in this work is not to prevent the use of data, but to ensure that the processing of the data is fair, lawful, necessary, proportionate, and secure. These concepts anchor the GDPP, which translate in international privacy standards in concrete policy guidelines. Let me move and look a little bit more in details at the GDPP. our legal framework. So the GDPP is the UNHCR overreaching data protection and privacy policy. It has been issued in 2022. It replaced and it expanded the initial UNHCR 2015 data protection policy that has the same principle and similar standard, but was focusing only initially on the persons of concern to UNHCR, and was not setting a governance framework. It was not setting a clear accountability to the policy. It provides a unified framework across the organization, and as I already mentioned, it extends beyond the persons of concern and applies to all individuals whose personal data UNHCR processes. Now, there are four main pillars. You see those in the slide. We'll go into each of these pillars more in detail, both on principle, in data subject rights, operational standard for implementation, and accountability and supervision. And UNHCR as international organization that has its own, as UN organization, has its own privileges and immunities, is not simply bound by one national data protection law. There are several countries in the world that properly put in place their data protection national law. But the GDPP is allow UNHCR to give effect internally to international privacy and human rights norms. Now, let's start from the first one. It's a little bit heavy, so I will try to go quickly one by one, and I'm happy then to have further discussion with you and hear from your experience as well. So fair and legitimate processing, these are the legal basis. UNHCR must have a legitimate basis for processing personal data. So we have several of the bases, legitimate bases, and they are listed in the policy. There is consent, there is a performance of a contract, vital interest, or the best interest of the child, necessity for investigation, UNHCR mandate, and UNHCR legitimate interest. Now, there are a lot of discussion also within the human rights board to always have consent. And this consent must have a certain characteristic, right? Consent is one of the legitimate bases to process data, but consent must be truly freely given, must be informed, and must be expressed clearly. It shouldn't be coerced or bundled with essential services. And why I'm stressing this, because this is particularly important, for example, in refugee operations, right? So when we do collect data for registration purposes, for example, in a refugee operation, most often the legitimate basis is mandate. And is not always consent. We also ask for consent, and that is the basis, but the mandate and the vital interest and the best interest of the child are central legal basis for registration or for protection case management or for life-saving assistance. Again, the consent remains extremely important, but in certain situations where dependency and power are imbalanced, we must be honest about when consent is truly given. So, for example, if I ask, I need to know a name of a refugee or an asylum seeker to be registered. We need to know this name. We do often, and we are required to collect, for example, biometrics. For accountability purposes, to anchor the identity or to avoid that while refugee receive multiple time the same assistance in this, and we all know the scarce resources we are facing. So you see, if a refugee says, no, I don't consent to share my name, I can't register, that exclude him from registration, that exclude him from assistance automatically. So there is it really freely given the consent? That's why the legal basis for registration are often mandated. Sorry, I just wanted to focus a little bit more on the legitimate basis because that's critical. And there are currently also a lot of discussion about it with other human rights organizations. Let's focus on the purpose. That means that we must clearly define why we collect data for each activity. So, for example, why we collect data for registration, we collect data for assistance, for protection, to avoid, and this is important to avoid to repurpose the data for unrelated uses in the future without that are not compatible with the basis for which these data were collected. So, for example, refugee registration data collected for protection cannot be automatically be repurposed for immigration enforcement or for broad security screening. Proportionality and necessity. This is what we call data minimization. We only collect data that is strictly necessary for the defined purpose for which that data are collected. In this technological age where collecting as many information as we want is extremely easy because of technology, I can simply record this code to collect all the information, right? The legal standard requires us to resist over-collection, especially for sensitive data such as, for example, biometrics. Principle of retention and limitation means that we cannot keep refugee data indefinitely just in case. Retention period must be reflect operational needs, legal obligation and risk, and be subject to review and deletion or anonymization. Accuracy. Inaccurate or outdated data may have serious protection risks and consequences on refugees. Often, for example, we do target assistance. We don't give blanket assistance to all refugees. And this is based on scoring, vulnerability scoring, and this scoring, if is calculated on inaccurate data, may exclude that individual from assistance. So the principle here is extremely important to avoid exclusion. And this also is linked to what we will look a little bit later to the data subject right of rectification, which as I mentioned, I will address shortly. Confidentiality and security means that data must be protected through appropriate both technical and organizational measures. So, for example, encryption, access control, a secure architecture in the database. So, data security is extremely important, and this is particularly critical when we use cloud services, or we talk about interoperable platforms with exchange of data between UNHCR and states that are the primary responsibility for refugee protection, or between other UN agency or cross-border data transfer, for example, when a refugee go back to their country of origin through voluntary repatriation, or if he's resettled to a third country. Transparency. Refugee asylum seeker, they must understand what data is collected for, why, by whom, it may be shared with whom, how those data are processed, and what their data are. That means that in practice, clear, accessible privacy notice adapted to the different languages of the refugees must be available. And we know that often these vulnerable communities are not literate, or in this digital world they don't have access to connectivity. So there are certain barriers. So principle or transparency is extremely important. Just imagine as individual, I know, I just give you a simple example. All of us faced, for example, we should, and we do as UNHCR, avoid the long legalistic privacy notice. Think about the contract that I signed with the bank and always has those 30 pages, small footnotes that I can't really understand. So we need to avoid that, and we need to be transparent with the population we serve. Accountability means that we must be able to demonstrate compliance through documentation, due diligence, assessments, and government structure. So these principles are not theoretical. They directly shape how UNHCR designs its system, manage biometric and biodata, and interacts with states and partners, and also empower refugees and stateless persons and IDPs through clearly defining their rights. So the policy recognizes a set of data subject rights that mirror but are not identical to their rights in national data protection. The right to information. So we already mentioned briefly, also as part of the principle, refugees need to be informed about the data processing. And remember, the data processing is everything from primary data collection to the end, is the entire process. The right of access, the data subject needs to have access to his own data, needs to know what data UNHCR holds about them. Rights to rectification, and we mentioned before on accuracy principle, for example, they must be able to correct inaccurate or incomplete data over the time. Right to deletion under defined condition, they also have the right to have their data erased, and the right to objection, meaning that they can object to certain type of data processing. So, for example, they don't want their data to be shared with certain actors, maybe certain NGOs, depending on the context, or partner stories, or obviously, as also Mr. Manoj mentioned before, the country of origin, because that would further, would definitely, if conditions are not met for voluntary repatriation, expose refugee and asylum seekers at serious security threats. So in practice, enabling these rights for refugees and stateless persons raises specific legal and operational questions. How do we balance the right, for example, to deletion with the legal obligation to maintain records for protection, for accountability that UNHCR has, right? Because we are also audited despite being a international organization. How do we handle objections where processing is necessary to prevent serious harm or fulfill UNHCR mandate, for example, collective biometrics? So the GDPP addresses these issues through procedures, and when necessary, a redress process overseen by identified and designated authorities. So to make these principles and rights effective, the GDPP, and we are moving to the last pillar, to the third pillar, the GDPP also sets operational standards, particularly relevant in this age of technology. The privacy by design and privacy by default. This means that we embed the data protection consideration into design of the system, processes, and technology from the outset. and not afterward. In refugee context, privacy by design means minimizing field in digital registration forms, for example, using pseudonymized identifiers for analytics, or building specific role-based access to users to see only what they need to see in the database, depending on their roles and responsibilities. And here, data protection and privacy impact assessment, what we call DPIA, plays a really important role. The GDPR requires that UNHCR carry out DPIA for personal data processing of activities that have high risk or likely involve high risk for the rights and freedoms of the data subject. And this depends from the nature, the scope, the context, and obviously the purposes of the processing of the data. So in practice, the DPIA is a legal and operational tool. It identifies risks, evaluates the severity and the likelihood of these risks to happen. And the DPIA documents the mitigation measure to these risks, such as the data minimization, the strong encryption, governance safeguards, or limiting data sharing only with, identified and selected entities. Personal data breach notification. The GDPR requires that UNHCR notify as soon as possible the data subject when personal data breach happens or are likely to, because this is likely to result in high risk for the security. I think we were all really surprised, but also, how can I say, worried when we heard about the data breach that ICRC had a couple of years ago, and we all, based also on ICRC lessons learned, and thanks to them, we really want to avoid that to happen in the future. So imagine, for refugees, even a perception of a breach can have serious consequences, including, for example, fear of refoulement or retaliation. Refoulement is, I guess we are all familiar with this concept, is when a refugee is forcibly pushed back to the country of origin. So it's really important that there is a transparent, timely, and protective response if a data breach happens. And ADM, so automated decision making. The GDPR requires particular care to automated decision making. And here we refer to, for example, use of algorithm or AI to take decision, right? That's what automated decision making is in this technological world. So key legal question arise: is there a meaningful human oversight? Can individuals can refugee contest the decision and request human review? Because this can have serious impact, right? So for refugee data, using ADM without safeguards risks encoding bias, discriminating against marginalized group, or making opaque decision about assistance. The example I gave you on targeted assistance, if this is based on scoring, and this scoring is automated by AI algorithm. So we really want to make sure that there is always a human review on, despite we take advantage of AI in this digitized and technological era. Sensitive data. We do process as UNHCR and government that take responsibility of refugees often do the same, process highly sensitive data. Let's think about, for example, biometrics or health information, detail about the persecution of the claim, religion, political opinion. All these have sensitive data. And so take, for example, biometrics. is highly sensitive, is irreversible. It doesn't change over time. And if it's misused, it exposes refugees to life-threatened risks, right? So the GDPP sets stricter conditions for processing this sensitive data. And for sharing this data with third parties, they can be government partners or contractor service providers, including the need and the requirement of have a data sharing agreement. And safeguards and adherence to the do not harm principle. Finally, the fourth pillar is accountability and authorities. And accountability is supposed by a governance architecture that includes the personal data controllers that designate units responsible for determining the purposes, data protection focal point. I am the regional data protection focal point in Asian Pacific for UNHCR, for example. And I do provide advisory role and operational support to our operations. Chief Data Protection Officer is based in Geneva and provide oversight and guidance. And the Chief Information Security Officer, CISO, leading on information security in this technological world, right? There is also a review committee for complaints and complex cases. And this structure is crucial to turn policy into practice and to provide a channel for individuals to seek redress if we arrive there. So now we talked about the legal basis and the policy, but I would like to focus and to illustrate this concept in some of the UNHCR digital initiative, also in India. So we have just three examples. One is the digital gateway. The other one is an application that is used by states in certain contexts, for example, in Malaysia and Indonesia, that is called Verify Plus. And then biometrics, iris, facial verification, and fingerprint. Now, digital gateway, just quickly, is just a digital platform that creates an easy accessible digital entry point for asylum seekers, refugees, for people, and they can use to get and exchange information with UNHCR, receive UNHCR services, and I listed in this slide some of the services, and find solution to their problem in a remote way, right? So avoiding face-to-face to prevent barriers for refugees to move into India. We have an office only in Delhi to move from Manipur, for example, up to Delhi, right? And clear additional barrier to these already vulnerable people. So we do take advantage of technology, and we must. But we also need to pay really careful, right, attention. And all the principles and the requirements that I just mentioned and have been set by the policy are reflected in this digital platform, the digital gateway, that can be mobile. And I will share with you the links if you want to know more. We just deployed the operation, just deployed into India. To open new doors for refugees, or can be in form of kiosk to issue documents eventually. For example, we deployed end of last year in Malaysia. And think about an ATM machine, not providing obviously cash, but providing legal documentation to it. Verify Plus. Verify Plus is an application, for example, a mobile app used by governments official to verify the authenticity of and the validity of a document. As every individual, sometimes, and this to strengthen accountability and to strengthen protection of refugees, right? To avoid that documents are forged and so on. It's a mobile app. Is available on iOS or Android. And through this QR code, when, for example, a refugee goes to a health center, the hospital is able to scan, verify through the app, verify that the document is authentic, is valid, that that person is the person that claimed to be, and therefore provide us assistance, medical assistance, and then bill UNHCR. Or empowerment entity, for example, police, can stop a refugee, verify the identity, the document is valid, is legally in country, and that protects refugee to be arbitrarily detained, for example. But there are a lot of information, right? Biometrics. And I do again the point, right? Biometric is extremely sensitive, irreversible. So imagine if these biometrics, look at the Rohingya, they are stateless, they are refugees. If these biometrics by mistake go in the wrong hand, it could be weaponized, right? And we really need to ensure that this is not happening. It's especially important for refugees because we need to remind that they're in a special condition. They flee persecution, right? And all these examples show that the GDPP is not a constraint to innovation, is a precondition for a responsible innovation that safeguards and rights and dignity of refugees are respected. So I really don't want to pass the message. Actually, I want to pass the opposite message that we are against technology. We want to take advantage of technology. We must take advantage of technology. And we need to do it in a responsible way. That's what the GDPP does. So in conclusion, and apologies if I was a little bit long, I just would like to highlight 4 key messages. 1, refugee data protection is the core protection issue. In the age of technology, the way we collect, use, and share data can either enhance or undermine the safety, dignity, and rights of the people that are forced to flee. The GDPP provides a robust legal and policy framework that translates their right to privacy and broader humanitarian rights standards into concrete principles and safeguards tailored to UNHCR mandate. The responsible use of technology requires governance. It's not just a tool. So privacy by design, data protection, impact assessment that we mentioned, breach notification, clear roles and strong oversight are critical to mitigate risk in use of technology in humanitarian settings. And going forward, collaboration is critical. Collaboration with state to ensure that national systems that use refugee data respect international protection obligations. Collaboration with other international organizations, UN or non-UN, and the national NGO to harmonize approaches to avoid weak links in data sharing chain. We need to share personal data to protect the refugee. With researcher and technologists to co-design solutions that are both innovative, but at the same time respect the rights and data security. So I leave you with this main key takeaway. I thank you very much for your attention, and I look really forward learning from your experiences as well. Over back to you. Thank you so much.
Thank you, sir, for your deep keynote address, for offering global perspective on humanitarian data governance. So we would like to seek some questions from audience concerning your presentation. Is there any questions from audience? Yes. And
Sorry, I wasn't unable to look at the chat because I had the screen.
yes.
So if there is any, I can.
Is there any question? Is there any question?
Sir, myself Madhavendra Chakraborty from Assam University. My question is that how should the delimitation initiatives and refugee eviction drives in India, including NRC, CAA, and SIR, be assessed from a constitutional and international law perspective? Specifically, do they comport with the Article 21, erga omnes obligations, and India's commitments under international
Your
refugee law
question is not.
and the human rights instruments such as the UDHR? Thank you
No,
so much.
your question is not in order here. Your question is supposed to be asked from Professor Manoj Kumar Sinha, our next speaker. So, sir is speaking from Bengal perspective, from data governance, not constitution.
Hello.
Yes.
Yeah.
Your question is relevant here.
Yes,
You can
relevant.
Yeah, right.
I think to answer your question about the
Yes.
CA, NRC, citizenship. So government is targeting and looking into it's not refugee. So first, we have to also make a distinction. They said they are illegal immigrants. They have entered in the Indian territory without any. They never asked for the refugee status also, neither to the government of India nor to the UNHCR, even those who fall into the mandate of the UNHCR. So government says there are, and this is a very unique case. We have amended our Citizenship Amendment Act in 1987, and there are since then number of changes has been done. So what we are noticing, government has noted the eastern part of the border, like an eastern part of country, see the population growth disproportionate to the other parts of the country. So they said there are a lot of people, they entered illegally in India and obtained all the valid document. They say they are the Indian citizens. So now the entire exercise, CA is a little bit different. CA, I'll keep it aside, but NRC is to identifying genuine citizen or fake citizen, and that is exercise even SIR is attempting to do. SIR, a special intensive review which is going on in the voter list, that is also the same exercise is going. But Citizenship Amendment Act is also some way different thing. It's not which we have amended our Citizenship Amendment Act. We made some insertion in the section 6A of the Citizenship Act, which allows only two important conditions. One, the persons who are entering in India, particularly minorities, the persons who are minorities in Bangladesh, persons who are minorities in Afghanistan, person who is minorities in the Pakistan. So they are the Hindus, Buddhists, and others like the minority. If they come to India, they will not be detained by the enforcement authorities. So the first. Second, they will allow to stay, even they are illegal. So first thing, Corner Act comes into operation to arrest them. So they will not be detained because Citizenship Amendment Act has been amended and the person coming from these countries are protected under the Citizenship Act. Its ambit has been also enlarged recently till December 2024. Earlier it was till December 2014. So that is different. NRC is just like an attempt. There are a lot of issues are there. Of course, what you are saying, there are a lot of things which we need to look into. But main objective to filtering legal or illegal, and that is the question. But in the process, there are a lot of if and but is also there. We have to look into that.
Thank you so much, sir.
Thank you, sir. May I now invite Mr. Alberto Matos, President Kalu Institute, Madrid, Spain, to share his remark. Sir, before we proceed with you, may I request Ms. Sarah Benjamin to introduce you to the audience and then you proceed further. Ms. Sarah, over to you.
It is my honor to introduce our distinguished president from the Kalu Institute, Mr. Alberto Martos, who leads from Madrid, Spain. Mr. Matos is an economist, educated at the Complutense University of Madrid with postgraduate training in NGO management and program design. He has dedicated his professional life to humanitarian education and program development, having worked with organizations like the Spanish Agency for International Cooperation, the Red Cross, Oxfam, and Caritas. In particular, his work has focused on internally displaced persons and humanitarian protection. Within Kalu Institute, he has played a key role in curriculum design, instructional leadership, and the institutional growth of humanitarian education programs. As president, Mr. Mathos ensures that Kalu remains at the forefront of capacity building, innovation, and field relevant learning for humanitarian actors. His leadership blends academic vision with the on the ground insight, a rare combination that has strengthened Kalu's mission to rebuild resilient systems and human capital in fragile settings. We are privileged to have him guide and support our initiative. Please join me in extending our warmest welcome to Mr. Alberto Matos. Thank you.
Thank you, Sarah. I want to start by saying thank you to you, Sarah, to Mysore University, to UNHCR, and to all the organizers. I think that this collaboration is really important to put together expert academics and practitioners to address this challenging subject. We are Kalu, and as you have said, we are focused on strengthening the humanitarian response, mainly by research and training aid workers. Every year, we train over 1,000 practitioners who are in the forefront of the humanitarian response, mainly in Africa and the Middle East countries. Well, let me start introducing the subject by saying that over these 2 days, we are going to talk about digital technologies, biometric, artificial intelligence, data systems, and cross-border sharing, and this situation is reshaping the situation also for refugees, and as they are affecting their rights, and probably they can increase their vulnerabilities. We are talking about refugees, IDPs, but also migrants. And I think that it's important to take a moment to talk about these terms, as they are very similar, and we use them sometimes without knowing exactly the differences. So talking about migration, the first category would be just migrant. A migrant is a person or a family who move normally to get a better job, education, or other opportunities. Of course, all these persons are migrants, but where we are talking just about migrants, we normally refer to this situation. Then we have internally displaced persons or IDPs, who are people who are forced to flee their homes due to conflict, threats, violence, or disasters, but they remain in their countries. They do not move to another country. Well, when one of these persons leave the country, it does not become a refugee just for crossing the borders. When a person crosses the border and feel these vulnerabilities, should start by asking for an asylum situation. They are called asylum seekers. So they have already left their country, but they have not yet recognized as refugees. And then we have refugees, who are people who have left their countries, because of persecution or security issues, but they have also recognized as such under the international law. We are talking about the 1951 Refugee Convention and the 1967 Protocol. Okay, all these three groups are governed by different legal bodies. Therefore, we have to understand the differences of this group because it also has legal implication. But this situation, many times we tend to use them as a proxy of the vulnerability, and we tend to think that migrants are not as vulnerable as refugees, and that is not always the case. So we can find a family who is really experiencing a refugee situation. They have security problems. They have to leave their country because of that, but they have not been recognized as such. So it is important to get to that legal status. And how does it work? The refugee status determination involves researching. The authorities have to find out about the particular situation of the family. The family has to collect evidences about the situation, and all this documentation has to be studied to later be taken a decision, and this decision can take months or even years. So it is not a fast procedure. To partially solve that situation, UNHCR and the states use a different protocol, which is the prima facie approach. That is a much faster way to determine the refugee status, and it's based on a situation like if you are coming from this country in this situation, we can assume that you are in danger and we can grant you a refugee status. This prima facie approach is mainly used in large-scale emergencies. But that gets us to the second problem. That is what I was mentioning before. The legal status is not the only thing. It is very important for the states, but for humanitarian organizations, the most relevant issue is the real vulnerability, the needs of the people. So we can use the refugee status and the other situation as a first approach, but it's not the only thing we will use, because we know that we can find families who has received this refugee status recognition who are, well, according to the situation, but they do not have particular material needs, and we can find families who has not received that situation at all, or even that are just migrant and has no possibility of getting any recognition as a refugee, that are in very difficult situations. So for a humanitarian organization, the main thing is the need, is not only the status. And then we have a third problem, which is the one that brings us together here. Nowadays, every one of us, and of course, every one of the refugees, asylum seekers, or migrants, or IDPs, generates a lot of information. And many of this information are sensitive personal data. fingerprints, iris scan, facial recognition, geolocalization data, family relationship, medical stories, pictures, voice recording, many information that is stored, that is analyzed, and it's many times shared among organizations without permission of the affected people. And that is not only data that is going to be used in an administrative paperwork. That information, the states and the organization use it in many other ways. We are talking about sensitive information that can get us to determine the ethnicity, religious, political affiliation, location, escape routes, and many many things that it gets to the wrong hands. If the persecutors get to that information, can get us to a tragedy. Well, these are the things that we are going to talk this day. We live in a world that we love to manage data, to use artificial intelligence, but we have to be very careful with these things. We have also a tendency in a world that we can't even leave the decision of granting a particular status to an automatization or to an algorithm. So maybe we can move to the insensitivity of a bureaucrat behind a desk to the insensitivity of an algorithm. Well, thanks again for let us be in this process. And in the next 2 days, we will be hearing the opinion of the experts to explore this problem. Thank you once again to the organizer, to all the speakers, moderators, and participants. Thanks, Sarah. The ground is yours.
Thank you. Thank you so much, sir, for such transitional academic collaboration. Now, I respectfully invite Professor Vishwanath M., Senior Professor, Chairman, PG Department of Studies in Law, Dean Faculty of Law, Karnataka University, Dharwad, to deliver his distinguished speech. Sir, before we proceed with you, we would like to brief about you to the audience, then you may proceed as the last speaker for today's program.
It is my privilege to introduce an eminent academic leader who has made significant contributions to legal education and scholarly pursuits. Professor Dr. Vishwanathan M., Senior Professor and Chairman, Postgraduate Department of Studies in Law and Dean Faculty of Law, Karnataka University, Dharwad, India. Professor Vishwanath brings with him a rich academic and teaching experience. As Senior Professor and Chairperson of the PG Department of Studies in Law, he has guided innumerable postgraduate and doctoral scholars, nurturing the next generation of legal thinkers and practitioners. In his role as as the Dean of the Faculty of Law, he has played a pivotal part in strengthening academic programs, enhancing research culture, and fostering intellectual engagement at the Karnataka University. His academic interests span across several key areas of law, and his leadership has been instrumental in shaping rigorous curriculum that blend doctrinal depth with practical relevance, a foundation that resonates deeply with the theme of our conference. Professor Vishwanath is widely respected for his commitment to excellence in legal scholarship and education, and for his mentorship to students and young researchers alike. Today, we are honored to have with us a scholar whose dedication to academic leadership and legal learning continues to inspire many within and beyond the university community. Please join me in extending a very warm welcome to Professor Dr. Vishwanath M., Senior Professor and Chairman, PG Department of Studies in Law and Dean, Faculty of Law, Karnataka University, Dharwad. Thank you.
Thank you, Sarah, for your kind introduction. Uh, First of all, my kind regards, and also it's a privilege to be associated with the Mysore University, especially my good friend, Professor Benjamin, the chairman and dean faculty of law, Mysore University. And it's also a pleasure and honor to be associated with Manoj Kumar Sinha, sir, the former director of ILI and also the present vice chancellor of the Dharmashastra Law University at Jabalpur. Sir, you have been always inspiring us across the country. Thank you so much, sir, to be associated with you. Kalu Institute of Spain and the UNHRC, who have been associated to conduct these wonderful sessions on refugee data protection. So I had a bit a mixed, you call it as something what you call as hybrid, because we are online, but my topic is bit hybrid. What especially Manoj Kumar Sinha sir stated that you become stateless, you become a refugee in your own country. So about the internal displacement. So I am trying to just touch about these two contexts of the refugees and the internal refugees, just for the attention that on what basis these things that we stand across. So please give me a minute so that I can open up my slides.
Yes, sir, you can share.
Yeah, I think the slide is on.
Yes.
Okay, thank you. Thank you. So I just titled it as Home Sweet Home Turning Bitter. We expect that nobody's home should turn bitter because we always have been so attached to this emotional context of having a shelter that is a home. So we call it a sweet home. So every house has a board, home sweet home. So what is the situation if it turns bitter for us? So the plight of the internal and external refugees in the wake of global development. So my context of development is mostly into the physical infrastructures that what the globe is pushing, particularly in India. And no country wants to be left behind when it showcases itself at the global platform. So what is the impacts that it has, maybe positively and also negatively? A tribute to the farmer, as usual. My first slides goes to tributing the farmer with whom, without whom probably we would not be here. So I am touching again on human rights because without that we cannot speak anything on any context connected with the refugees. So there are three things. It tells inherent dignity, equal and inalienable rights of all members of human family is the foundation of freedom, justice, and peace in the world. Do we consider ourselves as a human family is a bigger question for us. Because the way that how we are fencing ourselves or we are fenced ourselves as a nation state, whether our mindset will accept us to allow ourselves to be a global citizen as a part of human family is a bigger question that every one of us needs to ask ourselves. But I also understand it's not so easy as what we talk or what we put it across. And we also know that these boundaries have been marked by us in the maps, which have been imprinted into every child where he is born, telling that you belong to so and so state, so and so place, so and so country, so and so language, so and so culture, so and so food. That whether you are only great or you are great. So this is so indigestible when it comes into probably understanding whether we live in a global world as a global human in a human family. But the UDHR really tells that yes, all members of human family. So taking that into strides, believing that we are all of human family, we can probably progress from there. It has been 75 years down the lane, from 1950 to 2025, and you take the UNHRC convention from 1951 to 2026, 75 years down the line, we are passed across. So it is not the first that we are trying to voice this or raise this voice. It has been always done, and probably it keeps on going. So why do we talk about human rights? Andrew Gade has made a statement. I'm just trying to repeat that. Everything that needs to be said has already been said, but since no one was listening, everything must be said again. So I think this also remains on our template forever, because each time we keep on telling, and there are people who don't listen. So this is normalcy in the globe, but as academicians, as a person who compassionates with the context of human rights, would always keep speaking about this, because we keep on telling, okay, because nobody listening, but that doesn't stop us from saying. So we should definitely talk about rights as humans. So whether it is human rights or rights of human, also it makes no difference for us. So it encompasses of every aspects of our life, guarded, guaranteed, defended, and respected. Look, these words are so weighing on us. It is guaranteed. Now, guaranteed by whom? Who should guard? Who should be defending this? Who should respect this? The answer is we the people. Okay, until I believe that, yes, I am a human, the other person also is a human, I don't normally guarantee myself that my rights will be protected somewhere else, until I guarantee myself that if I guarantee somebody's rights, probably I may also get into the same shoes one day. So it will come over to me that it is guaranteed, it is guarded. So that is where the context comes, that who should guard, especially the refugees, defend them. Okay, in what context that we are trying to state? Respect them, obviously, because everybody are humans. I'll come back to this when we go on further. It's a foundation for political, economic, social, and judicial structure of human freedoms. Obviously, it's on point that nobody can deny that the context of refugees is always apolitical. Economic, social may come later, but it is the political ideology that probably prevails as to whom do you consider as refugee, or you expect them into your country, and try to provide them certain things that is expected on that particular basis. So it definitely foundation, human rights is foundation. It is for the prevalence of peace, security, stability, and development. So that is where the context of development do also come. So peace, security, stability, you're going to establish this with development. And it is also a prerequisite for the prevention of conflicts and the promotion of a durable and lasting peace in the world. So we expect that these things would definitely bring us peace into the global platform. So we all know how disturbed the world is today in so many parts of the globe. And I strongly believe that none of us can watch ourselves that I'll be safe enough with this kind of volatile situations, or the leaders probably what we have, until we sustain and restrain this context of what we are as humans. And mostly it is the vulnerable groups that gets targeted. And who are these people? Whom do you call them as vulnerable? It's very evasive. Each one probably has his own way of trying to define vulnerable, but it's something in common understanding. People who are easily susceptible to physical or emotional injury, or subject to unnecessary criticism, or in a less advantageous position in this society, may be defined as vulnerable people. So I would stick on to somebody who is a less advantageous position for various reasons. Whoever has been in the fear of persecution, or has been forced to move because of a calamity, maybe natural or man-made, maybe the wars, which is pushing people outside the country, maybe some calamities like droughts, which pushes where you migrate, you want to force to migrate from one country to other country, and especially you're termed as a refugee. So development context, I'm just mixing up this both. Please bear with me. I'll come back with a proper linkage of these things. Uh, when Lenin to Stalin, big dams formed the core of the strategy for transformation of USSR into a industrial superstate. That means development. The core idea of development is to build something big and showcase that this is what we can do, and it achieves something has trying to be a #1 state across the globe. Big dams were at the heart of Roosevelt's public works entered a New Deal. To newly independent state leaders like Nasir, Nakram, and Nehru these were powerful symbols of the country's pride and progress, temples of modernity. To Premier Verrod, they were the symbol of appetite, power, and minority rights. So every leader has one strong understanding that you build things big, it's an indicator of development. So I do agree that we need development, not that we want to live in the forest eras, but the context is that at what cost that we are trying to look in developments and what would be its cost. So when it comes into project displaced people, that I'm just trying to highlight what even Sina sir also was trying, that when people normally get forcibly displaced in the name of projects and development, maybe dams, highways, cities, urbanization, airports, wildlife sanctuaries, all those things. And believe me, with all my experience and when the research, what I had done in the context of internal displacement, I am very clear that most of these people or those people who are going to get impacted by this developmental works or developmental projects would be majority the rural areas, maybe the tribals, the working class, the farmers. These are the people who gets affected. So this is where I think we are supposed to understand that the threat of being pushed out from your homes becomes really, really worrisome, and we should worry because these people are helpless. Like becoming a refugee, being forcibly ousted from one's land and habitat by a dam, a reservoir, or a highway is not only immediate, disruptive, and painful, it is also fraught with serious long-term risk of becoming poorer than before, displacement, more vulnerable economically, and disintegrated socially. So the agenda is that very clear that you become like a refugee. So a refugee and become like a refugee, similar and same. This is how the context I want to put. You cannot tell same and same, but you can tell similar and same. But similar may not be same. But they match. They really match because it is identical. So the internal context of refugees is definitely identical. You may even call them only displaced but not refugees. But it's a serious question, especially in a bigger country like India. If you compare Europe, for example, you can easily cross over from France to maybe to Switzerland, Switzerland to Germany, Germany to Sweden, Spain, Hungary, Denmark, very small countries, and if you are seeing their borders, you feel it is as a next door, next home, but not like those border like US or India where we are trying to fence it up across the borders. So the context of a European mindset when you look into somebody crossing into a country and in Asian countries, especially India or in US where the nation states are quite big enough, the internal displacement is not focused at all. Maybe we lose sight because of the definition that what we are trying to put across 75 years back regarding the refugees. I just have some few pictures for you to just glance. This picture is regarding the partition picture, that what we see regarding India and Pakistan when the most of the people, especially in North uh, India were forced to go to Pakistan, or from Pakistan they were forced to come to India. Of course, it was based upon the religion context. I do believe some Hindus stay back in Pakistan, some Muslims stayed back in India, and South India would have probably not would have impacted on this context of partition. So the refugee scheme that went on from 1947 to 50, and what do you see in the Indian Constitution as to the who is a citizen. So even there is a scope from this gap of 1947 to 1950. This is a picture from Africa. I am maybe from mid of Africa, that you just see how difficult it is for somebody to just move out from their place. Anybody who has moved from a rented house to another rented house knows the pain of moving from one place to other place carrying all his belongings. It's not so easy, because the attachment that you have with the home and going to the next home is really, really tough. So this is one of the picture from Africa. This is the Italian marine ship which arrested the illegal migrants, that is the refugees who are forced to move from Africa to Europe. It shows what happened in Europe, and this one picture which caught the eye of the globe, the Syrian crisis, where people were passing on the oceans for a safer and better place. And every one of us know the humanity crisis that were telecasted on the televisions, and what the global leaders did. And of course, we do understand that how the nation states have trimmed up their invitations to the migrants or the refugees, maybe in Europe or any part of the globe. So they are trimmed up. There are so many reasons for it. And this is not only a refugee context, it is definitely a humanitarian crisis that every human should look into. So this is the Indian context of displacement. The picture may be very few people, but the impact is too much that we look into. This is the UNHCR data that tells that refugee hotspots around the world right now, what has happened in Gaza Strip refugee camps has the highest number of refugees. And these are the stats that have been collected by the UNHCR, and I'm just trying to showcase here. See the Bazaar refugee camps, Gambela refugee camps, Dadaab refugee complex, White Nile refugee campus. So all those things that you see across. One interesting context where India also is connected is the Rohingyans Myanmar context. Even Sir was mentioning about this. So this is from 1970s. The slide shows from 1970s how people have moved from Myanmar because of continuous conflicts in the country, maybe the civil war or the persecution context of being minority or something else. See the spread of this one example of the country, how refugees get scattered. So there are people more than 2 lakhs in Saudi Arabia, 3.5 lakhs in Pakistan, Bangladesh has more than a lakh, UAE has 10,000. The southeastern countries like Thailand, Malaysia, Indonesia also holds this baggage of refugees from Myanmar. India also holds. And we also understand that the conflict in India is telling that at what clearly Sir was trying to tell, that most people are illegal immigrants. So there is a threat, security threat for the nation countries. We want to stop it, is the reason why most nation countries have trimming up. And it is valid also for the security reasons. But the context is that when you see that these people would probably having no documentations from where they have exited. So once when they are exited from one country, losing everything, they are barehanded, and they're just moving to survive, then how do they seek the status of this refugee or an immigrant is a bigger question that what we are supposed to look in. So when we look into the CAA or the SIR, the context is if you ask a document and people fail to produce it, where are we going to end up? Is a bigger question when it comes into these kind of situations. So I believe strongly that we need to understand maybe in a different perspective when it comes into this kind of situations. Let us not get emotional into the context of national securities. We do need that, but we should balance it with a humanitarian angle. So this one slide where I got where it is trying to tell that India sees relatively few refugees from CAA countries. So everybody knows the CAA, the SIR, the registration NIR that is going to happen, citizens register, national citizens registration, NCR. So Sri Lanka has 91,000, Myanmar, China, Afghanistan, Bangladesh. So all these countries do have some refugees, asylum seekers coming to India. So these few slides of this data shows us that the people keep moving because of so many reasons. And one strong reason is basically the political instability and the threat of being hurt or being killed in their own countries for various reasons. So that is one of the context of this refugees moving from one place to other place. And if you look into the history of India, India believes in Raj Dharma. We believe that somebody comes seeking protection. We have been always in forefront to give them the protection. This is not something new to the Indian civilization. We have been practicing that since ages. Times have changed, and it appears that we are also trying to bargain it hard that we don't allow somebody. This is not a country where anybody can come in and seek shelter and try to create some trouble. Is also one of the apprehensions that we are into. You take the Dalai Lama's Tibetan refugees, asylum seekers who came to India. I stay in a very close place, which is hardly 50 kilometers, where we have got a Tibetan refugee camp in Mundgod. And my friend sitting in Mysore also knows that he is also so close to a place which is hardly 60 kilometers from his place in Kushal Nagar, in Bailkopa. They have got a Tibetan refugee camp. So we have visited, I take often my students to also see from 1950s how India has protected especially the Tibetans who have come to India through the route because of the threat of this Chinese persecution to the entire the threat of maybe the religion as well as the political context. So India has been doing this. For example, if you would look into the north, that is the Tibetan, you go to the south, you have the Sri Lankan crisis. So a lot of Tamil-speaking Sri Lankans moved to India, when there was a crisis with the LTT and the Sri Lankan government in Sri Lanka. Of course, we became more alert when the former Prime Minister of India was assassinated by the LTT groups. So we were more scared or threatened that these unwanted groups of terror activities or somebody who is more violent enters into India may set up their illegal activities in India. So there are more than 5 to 10 lakhs of Tamilians, if I'm not wrong, staying in Tamil Nadu seeking as refugees. So India is not new for this kind of context. If you see especially Europe, post breakup of Russia, since 1980, late 1980s, so many countries were declared independence, and everybody knows what happened in those countries, especially Kosovo, Bosnia, Serbia, Albania, you name, which are connected to Europe, and how people have migrated, forced to move out of their nation state. So it is a global phenomenon that has been taking place, but the threat is that in the context whether we are trying to allow them into our countries or not. So this is one part of looking the refugees, maybe the unrest that what is there in their own countries, which has pushed them for certain regions. So inside the country, as I told, as in the name of development, we tend to push up the people, especially country like India. You see the numbers of the people who have been displaced and the global refugee picture. We can match up easily because of the internal displacement. And unfortunately, these people are not recognized as refugees, neither they get the treatment what the refugees do get. A few of my students, when I went to this Bailkopa, this when we were Mundgod, my students asked, "Sir, these refugees has better life than an Indian outsider. They have got all facilities. They have got fencing. They have got the security, the schools, hospitals, their culture, tradition has been protected to be continued." And sir was very clear that, of course, everything that is there in the constitution is also applicable to them. But some of them felt that they are probably much higher than the Indian citizen themselves. Okay, maybe, but that doesn't mean that they become citizens or they enjoy something more than that of a citizen of this country. It may appear to so that they have better facilities, but as I told, home is home. You cannot stay in somebody's home for a very long time until you make it your own home, but it's not so easy. So, moving on, this development, how it has impacted, I'll just browse it. So it tells that development in the name of dams or whatever it is, especially in India, we are constructed super dams because we are trying to compete with China, building up huge infrastructures, trying to economically grow. Okay. So, but my question is, what is development? As to what do we understand as development? So again, it is all definitely subjective. It cannot be objective in the context of development. But my contention as to development is human development, and not only the physical infrastructures that we are trying to put it across. Sorry, we need it, but I don't want to bargain with the cost of the human context where they suffer because of this development until they are made partners to those particular context. So it is multidimensionally involved, very the concept development itself. So Geneva in ILO in 1976 has come up with something called as to measure development. I really like this. The terms of fulfillment of people's physical and cultural needs like food, water, nutrition, shelter, health, education, and security, and in the context of developing countries. The objective of this approach was to overcome the problems of hunger, malnutrition, illiteracy, infant mortality, and morbidity. Of course, 1976, we have moved 50 years ahead. But development is to provide these things like food, water, nutrition, shelter, health, education, security. So, in this name, can we try to displace people? Is the question. So I understand that any development, especially physical development, needs some space, needs maybe larger space, and you need displacement. I'm not worried about that you trying to displace them, but I'm worried that what would be their fate that the government takes on to give them back what they lost. So that is where I think the disturbance starts, and we end up as equally as the status of a refugee. You find a replica here as an internally displaced person. So internal development in real terms is to be understood as participation of increasing proportion of country's population in growing material, social, and cultural wealth. So this development, especially for developing countries in India, African continent, is very vital. The capitalist model of development is now clearly on rise with its agenda of transformation towards modern industrial market economists justified morally as the best means to combat poverty and to raise standards of living on global scale. I do understand the importance of economics, but we all know that the real global picture, how there is the gap that is becoming much wider and wider between the rich and the poor. What is 1% of the population of the globe holding? What is the resources that are into? Okay. So I would try to put across Arjun Sen Gupta's development in a right-based approach adopting 5 principles for human rights. When you call development, I want this to be involved. Equity, non-discrimination, participation, accountability, transparency. And we expect that this thing should fall into line so that even if there is internal displacement in the name of development, people become partners of it. So they don't get agitated. So that's where the real development is. You see that, yes, the real development has impacted my lives in a positive way. It should not be something negative. So these are so danger that we tend to forget the backdrop of it, the people who have lost their lands, their homes for developing in the name of development. For example, the downstream of a dam will become a victim. The upper stream of a dam will become a beneficiary. Because the way that it is looked, the upper stream the upper stream is always it is acquired. The downstream people will get the water, will get the electricity, will get better agricultural land, and their economical progress is much huge. So these things are a reality, but how are we going to manage this? I love this way Sri P. Sainath has put across the impacts that how we people actually behave. It's a global phenomenon. It's not only connected with India, it's a global phenomenon. How organized we are over how people die, how uncontrolled or untroubled we are, how they live. So this is the point that we should always stick on when it comes into refugees or the people who are displaced. That we always cry on television, we always show aghast telling that, oh my God, so many people have died. Are we worried that how actually they live? So this is what the difference actually the reality is. Okay, we are so organized to when you see people dying, especially these people who are vulnerable. But we don't see the backdrop why they became like that or what we would have done better. So it's not so easy. So this one shows that what they lose. This is internal for internal displacement, but this is applicable even to the refugees at any given point of time. So they become landless if their land is taken, jobless, homeless, marginalized, increased morbidity, food security, loss of access to common property, social distraction, and ultimately it has a lot of mental agony to us that you lose hope. So once when you lose hope, everything looks hopeless. Then everything looks hopeless, you become helpless. When you become helpless, you find that your place has become a hell. So where to move around? So these are all really the bigger questions that is put into us. So core context that what I am trying to put it across is when these refugees move in to other countries, how UNHRC plays a major role in trying to stabilize those things, and the receiving state, the nation state which receives them, is also quite apprehensive as to what happens if these people come into country. That's why you collect data from them. So there is nothing wrong in collecting data, and the consent became a bigger issue. Somebody asked so many questions. Consent should be there. Look, I would tell, look, if you fall into the shoes of any of these refugees, will understand that I need a passport to go to Spain. If Kalu Institute invites me tomorrow, I should go to Spain. So I need a passport. I need a passport. That's why I apply. I go to passport office and I'm ready to give my iris scan, my all fingerprints, whatever they ask, I'm ready to give. Okay. So we agree that is consent, that I am giving consent for all those collections of my iris scan or the fingerprints. Okay. But one thing is understand, I'm willing to do. At the refugee point, look, as we tell, I'm sorry to use this word, but still, a beggar has no choice. You cannot have a choice of your food. That is their situation at that particular point of time. So the ons is on the government or the state which receives the data to protect it. You cannot blame the person telling that he has consented, he has not consented, consent does not come into picture at all because he has no other option. So instead of probably pressing on the consent, I think we should move on with the responsibility and the accountability of the state to protect the data. Because everybody knows that a person in US, if he applies to right now in the regime, present regime, if somebody applies to US, probably they may check my all social activities on my WhatsApp, my Facebook, Twitter, Instagram, whatnot. Okay, then they decide whether I should get a visa or not. Just imagine what happens to a person who becomes a refugee to move on. With this particular collection of data and it is leaked, everybody knows what is the social activity. The situation is different. That when he was a free man, when he was as good as others, his activity may be different. But when he is in distress and is forced to leave from one country to other country, if you are judging him only on that basis, definitely I think we may all end up means the refugees may end up in trouble. So I don't think we should predetermine because of his activities that what he has done using his digital space should decide his fate as a refugee. I'm not denying also that should not be probably pushed over. No, maybe the nation state may scrutinize, but as I told it is all subjective. How do you see? So until we have a neutral element playing, trying to see the globe as a human family that we are all into, then only we can try to absolve these things much better, maybe technically and legally both. So I believe that either it is internal displacement or the refugee is moving from one country to country or a status of refugee are same and similar. So both needs to be addressed in a humanitarian way, and it needs a lot of strength and courage to accept things at what we stand for, what values we are into. So I expect that every nation state understands this and tries to help each other as humans. But I know that it is not so easy at all to bring in this human rights or the humanitarian context so easily because of the sovereign state rights, nationalist attitude that we have got been built up so strongly. We cannot deny all those things. But definitely we can be trying to put across this because if it is ethical in nature, I just wanted to end up with one more slide. Ethics is knowing the difference between what you have a right to do and what is right to do. So I believe strongly if you all bound by this ethics, then we should know the difference between what you have a right to do and what is right to do. So if we are able to distinguish this, I think we can be able to move forward much better. Okay, thank you all for your kind attention. Any questions? I am open for it. Thank you.
Thank you, sir, for your scholarly and analytically rich keynote contribution. Is there any question? So we shall conclude today's program. I now invite Ms. Sarah Benjamin to kindly propose the vote of thanks for today's program.
It is both an honor and privilege to deliver the vote of thanks at the conclusion of the inaugural session of the two-day international conference on the legal dimensions of refugee data protection organized by the Department of Studies in Law, University of Mysore. At the very outset, I extend our deepest gratitude to our chief patron, Professor Dr. N.K. Loknath, Honorable Vice Chancellor of the University of Mysore, and our patron, Srimati M.K. Savita, Registrar, University of Mysore. Their constant encouragement, academic leadership, and institutional support have been instrumental in making this international conference a reality. A heartfelt thanks to our chief guest, Professor Dr. Manoj Kumar Sinha, Honorable Vice Chancellor of Dharmashastra National Law University, Jabalpur, for his inspiring inaugural address that has set the tone for meaningful deliberations ahead. We are equally grateful to our guest of honor, Professor A.M. Khan, Honorable Vice Chancellor of Karnataka University, Dharwad, for gracing this occasion and for his esteemed presence. Our sincere appreciation goes to Ms. Ragini, Associate Protection Officer, United Nations High Commissioner Refugees, New Delhi, for her collaborative remarks and for strengthening the partnership between academia and international humanitarian institutions. We express our gratitude to Mr. Alexandro Tello, Senior Data Identity Management Analysis Coordinator, UNHCR Regional Bureau for Asia and the Pacific, Bangkok, for sharing global perspectives on refugee protection. We also thank Mr. Alberto Matos, President, Kalu Institute, Madrid, for his thought provoking address on contemporary migration frameworks. A special note of appreciation to Professor Dr. Vishwanath M., Senior Professor and Dean, Faculty of Law, Karnataka University, Dharwad, for his insightful deliberation on the plight of refugees in the wake of global development. We gratefully acknowledge the leadership of Professor Dr. M.S. Benjamin, Dean, Faculty of Law and Chairman, Department of Studies in Law, University of Mysore, for his visionary guidance as the president of the program. We also extend sincere thanks to Dr. Syed Kudrat Hashmi, coordinator of the program, for his tireless efforts in planning and executing this event with great precision. Most importantly, we extend our sincere appreciation to the entire technical and media team working behind the scenes for ensuring smooth streaming, connectivity, and technical support throughout the program. Your efforts, though invisible to many, were crucial to the success of this event. To all our participants, faculty members, students, researchers, and distinguished attendees from India and abroad, thank you for your presence and engagement. It is your participation that gives meaning to this academic gathering. Thank you once again and wishing everyone enriching deliberations in the sessions ahead. Thank you.
Thank you, sir. Thank you.
Thank you. Bye.
Bye.